Hi, you found our video entitled Don't Act as a Broker-Dealer. I'm Gene Trowbridge of the securities law firm Trowbridge Nieh. If you have any questions after this video, just contact us. You can use our phone line, you can go to our website and sign up for a free consultation, or you can find other YouTubes we have on other topics right here at our channel. Be sure to subscribe. So let's talk about being a broker-dealer. A little bit about myself. I'm a former syndicator. I've been in this business a very, very long time. At 45, I went to law school. I taught CCIM classes for 40 years. I have a book. It's a whole new business, and I'll show you how you can get a hold of some of that material at the end of the video. And I'm an old runner. I'm still a half marathon runner, slower than I used to be, but I still do it. That's how I keep active. So the question is, are you acting as an unregistered broker-dealer? You are if you're selling securities for someone else, and you are if you're accepting compensation to sell the securities. So generally speaking, the securities laws in the United States came about in the 1930s. There was the 33 Act and then the 34 Act. The 33 Act defined what a security is, and we'll talk about that in a little bit. But the 34 Act set up a whole division, set up the SEC and licensing provisions, and gave them the responsibility to make sure that whoever is selling a security is registered, because the issues in the two securities laws, the 33 Act, the issue was disclosure. Are we telling the people what they're investing in? Do the people get all the information they need to make an informed decision before they invest? So the purpose of the 33 Act was full disclosure. The purpose of the 34 Act is, do we have people out there selling fraudulent deals? Let's see how we can stop that by educating and licensing people who sell securities. Okay, so if you're selling securities for someone else, you're going to need a license. And if you're accepting compensation to sell a security for someone else, you're going to need a license. If you don't have one, you are going to be found by the courts and the SEC as being an unregistered broker-dealer. Now, here's what a security is. A security, when multiple members invest their money in a common enterprise with an expectation of profit, but the whole enterprise is going to be managed by a third party. So the members are going to invest their money, but they're not managing their own money. They're not making their own decisions. All the money in the investment is going to be managed by the manager, and that's what makes it a security. There are 4 prongs under the 33 Act of a definition of a security: an investment of money in a common enterprise with an expectation of profit through the results of the sponsor. So if that's what's going on, it's a security. Now, who can raise money in a security? Well, the 34 Act says you need to be licensed to raise money in a security, except for the issuer exemption. Very important. You all know that in real estate, you can sell your own real estate without a real estate license, but you can't sell mine. You have to be licensed to sell my real estate and get compensation. Well, that's the analogy of the issuer exemption in the securities laws. Members of the manager who have some certain qualifications can sell the securities in investment LLC to the members, and they don't need to be licensed under what's called the issuer exemption. I would have called it the for sale by owner exemption, but it's the issuer exemption. So if you're going to be a member of the manager, you don't have to worry about being licensed. to sell securities. But what this video is all about is when someone comes to the manager and says, I'm over here, but I could raise $1 million for you. My investors will bring their $1 million a year, and I'd like to get paid. Okay. I might call that an enhancer. We use enhancers for various things. Maybe you need more net worth or liquidity to get the bank to loan you money. And maybe you need someone to help you raising money. Okay. But if this is a security and you're not a member of the manager, you're just going to play an enhancer role. And that enhancer role is to raise money. You need to be a licensed securities broker. And if you raise money and it goes into it goes into the fund, and the manager pays you for raising money, and you're not licensed, you're acting as an unlicensed broker dealer, and you're in trouble. There's no doubt about that. That's against the law. So if you're found to be an unregistered broker dealer, here's what can happen to you. You can become liable for penalties levied by the SEC or the state securities regulators. The SEC may go after you, or the state in which the investor is located, where the investor invested in the deal through you, can go after you. You could be subject to a cease and desist order from the SEC. And once you're subject to a cease and desist order from the SEC, you'll never be able to be involved in the securities industry again, not even doing your own deals over something called the bad actors provision. You can be subject to a rescission action from the investors. I have found that this is the one thing that people who act as unregistered broker dealers don't know. Let's say in our example, you brought $1 million into my deal, and I paid you $25,000. 5 years from now, my deal goes bad. Everyone loses their money. Sure, I'm probably going to get sued, but that isn't so important to you. What's important is because you acted as an unregistered broker dealer, your investors, your $1 million investors, can come after you in what's called a rescission action and demand you give them their $1 million back. I bet you didn't know that. You made $25,000 for selling some securities when you were an unregistered broker, and now they will take you to court. And if successful, you will get a judgment against you for $1 million that you'll have to pay to the investors. Probably not worth it, right? You may be subject to a temporary or permanent injunction, limiting your ability to be involved in future securities transactions, whether it's your transaction or someone else's, and subject to criminal penalties, primarily enforced at the state level. When we do a securities offering, we send a form to the SEC to tell them that we're doing the offering. It's an information gathering form. But the state law requires that every time there's an investor in a state, we have to send a copy of that form to the state along with some documentation and a check so that the state knows that you've been in their state dealing with their citizens. Now, you may have 20 investors from one state, but you only send one letter and one check. So the state knows you've raised money from their citizens. Why is that important? Because the first call a citizen will make is to the state securities broker. I mean, the SEC is a big place. You think anyone's going to listen to you? I don't know. But the state, you have a nexus with the state. So the first place you call is the state. And the state can look through the records and find out who did the deal. And then they can track it back to you. So if you've been acting as an unregistered broker dealer, you could be subject to criminal penalties enforced at the state law, whatever the state laws are, as it relates to where your investors came from. So here's what I think. as far as raising money for other people's entities, whether you get paid or not, but certainly if you get paid, don't do that. There are ways to resolve this. You could form your own syndication and bring all your investors together. There you're the issuer and you're fine. And then you could simply have your syndication become an investor in the deal. You're responsible for your people. You're going to get one check and one K1, and then you're responsible for managing it. That's fine. But just don't sell someone else's security unless you have a securities license. Now, we spent a lot of time talking about that in the chapter of securities laws, which is inside of my book. And you can get my book by going to book.tnllp.com. We'll send you a free PDF. We'll tell you how you can get a copy of the book and only pay for shipping. And I think we tell you that the book is available at Amazon on an Audible version in which I narrated the book, and you could listen to me talking about the book, which is pretty interesting. So that's what I think would be a good idea for you if you want more in-depth information about all the things that go on in being a syndicator. If you just simply have questions, call us. Go to our website, sign up for a consultation, a free half-hour consultation with one of our lawyers, and subscribe to our YouTube channel where you are now, because there are a lot of YouTubes that we have that talk about all different aspects dealing with being involved in the securities industry. So thanks a lot, and we'll see you at another YouTube.